Yeah, so good morning. Thank you to everyone who's here. We've already heard a crowd ranging from Puerto Rico to Florida, everywhere in between. So thank you for being here. We just have a little intro and then we'll get started on presenting our work. So good morning, and on behalf of Executive Director Diane Russ Tierney, I'd like to welcome you to the third of a series of webinars sponsored by the National Coalition to Abolish the Death Penalty. And this series, Justice Powered by Information, is an educational series designed for individual grassroots activists. And it's designed for expert panelists to share information and insights that will inform and encourage grassroots activists, particularly those of you who are new to the struggle, with news and information that you guys can share on your personal networks to continue to build momentum against the death penalty. And each of these webinars is designed to provide participants with the opportunity to take immediate action to share what they've learned. And NCADP is excited that all of you have taken the time to join us this morning. And after this webinar, each of you will begin to receive our newsletter so you can stay current on what NCADP is doing and get the schedule of upcoming future webinars. And if you have any questions or need further information about NCADP, please visit their website at ncadp.org or contact the office directly. And with that, we'll get started presenting Deadly Justice. And we have three of the authors of this work here. My name's Arvind Krishnamurthy.
I'm Frank Baumgartner. And we have also online Marty Davidson, who will be joining us in just a minute. Two of our co-authors are not available to join us, but we have three of the five. I wanted to explain a little bit about the general idea of the book. It's quite simple. The idea is to ask, now that we've had 40 years experience since 1976, when the Supreme Court validated what's called the modern death penalty after the 1972 decision to invalidate previous versions of the death penalty and historical use of the death penalty, which had been found to be arbitrary and capricious. Now that we have 40 years of experience, how can we evaluate the modern death penalty? So, in 1972, the Supreme Court ruled that the historical death penalty was unconstitutional because it was arbitrary and capricious. It was similar to having been struck by lightning. There was no rhyme or reason as to why one person got the death penalty out of tens of thousands of murders each year. And if there was any pattern to it, it was the impermissible pattern of racial bias. So the states immediately rewrote their laws quite quickly, and by 1976, the Supreme Court ruled against two of those laws, in North Carolina and Louisiana, which had mandated mandatory death for people convicted of capital crimes. But it validated a series of new laws, Texas, Florida, and Georgia, that purported to narrowly target the worst criminals who had committed the worst crimes, and only such criminals would be targeted for the death penalty. So our question is very simple. After 40 years, what does our collective experience show us? So the book is designed into a number of chapters, each of which is quite simple. Such things as which types of homicides lead to execution, have states narrowly targeted the worst of the worst, etc. And our overall assessment is very simple. Do we pass the Furman test? Do we fail the Furman test, or do we pass the test laid out in the Gregg v. Georgia 1976 decision, which was supposed to mandate narrow targeting and proportionality? A litany of problems that were identified in 1972 are still apparent in the modern death penalty, according to our analysis, which we'll go into detail. It's got a very low rate of use, and so that low rate of use compared to the vast number of homicides in America invites caprice and arbitrariness. The death penalty in the modern era is highly targeted at just a few, it's highly concentrated in just a few geographical jurisdictions, such as the city of Houston, Texas, and the surrounding county of Harris County. A number of extra legal factors continue to plague the death penalty, making it more common that black defendants with white victims are more likely to get the death penalty than other types of crimes. It has not, in fact, been narrowly targeted. Most of the states could not risk the temptation of adding such vague, aggravating circumstances as particularly heinous crimes. We go through these things one at a time in the book. In addition to things that were previously ruled unconstitutional in Furman, the modern death penalty also exhibits certain very troubling characteristics that were not there in Furman that justices had not considered. For example, since 1976, 160 people have been exonerated, having been proved to be innocent and released from not just from death row, but from prison altogether, and are now free. So 160 exonerations has suggested that the system is very imperfect. Also, in the modern period, even though someone might be solemnly condemned to death, condemned to die in a solemn confirmation by a judge, 70% of the time those death sentences are overturned on appeal. Similarly, and perhaps most surprisingly, even when a governor signs a death warrant laying out a date for the actual execution, most of those are canceled. And finally, delays typically now mean that the death sentences that are carried out 20, 25, and even sometimes 30 years after the actual conviction. Finally, it's also true that the cost of the death penalty has risen to astronomical proportions, which does change, I think, some of the political calculus about the death penalty, if not the moral or the legal issues about it. And the death penalty also has been in declining use, so this opens up a constitutional argument about evolving standards. So at the end of the day, we view the death penalty in terms of a government program. If we analyze the value of the program, we have to say that the new improved death penalty has failed to live up to the promise presented to the justices by the state of Georgia in Gregg v. Georgia and in related cases. The new system has not solved the problems identified previously, and indeed it maintains almost all of them. Some of them are even worse. But then there's new problems such as costs, delays, reversals, and botched lethal injections.
Yeah, so Frank went through some of these reasons why maybe the modern application of the death penalty hasn't met the standards the court set out. So here we're going to go through and look at the evidence that we present in our book that shows why empirically they haven't met those standards. So first, to kind of understand the backdrop is to look at how many homicides take place over time. And as you can see, over 10,000 homicides have occurred in every year since 1960. But for the purposes of the death penalty, it's important to consider what proportion of those homicides actually lead to a death sentence. So you see here, since 1976 and the modern application of the death penalty, it's about 1% of all homicides actually lead to a death sentence, which is a very, very small number, and an even fewer number of those actually end up getting executed. And you see here, it's something that we touched on before. The most common outcome when you get a death sentence isn't that you're actually executed. The most common outcome is that your sentence is reversed or you just remain on death row. It's a small proportion of individuals, 16%, given that you got a death sentence, are actually executed, and reversals are 3 times as likely. And there are differences in who is executed from who is killed and who are the victims of homicide. So in homicides, 47% of all homicide victims are black, but for the victims of those who are executed, it's only 16.9% are black. And that means that white victims are overrepresented in who is executed versus who is killed and female victims have a similar ratio, where female victims are only 50% of, I'm sorry, female victims are 76% of all homicides and 50% of executions. And so this leads to this figure, which I think is one of the most striking figures we had in our book, which shows that the race and gender of the victim is a really strong predictor of who ends up being executed. So if you kill a white female, your odds of being executed are 12 times higher than if you kill a black male. And that shows a big disparity, which raises the question that we talked about earlier about narrow targeting. So is the death penalty targeting the worst of the worst? And we see here that in not over 90% of all homicides in Arizona, for example, are death eligible. And that's saying that because of these vague statutes, it's very hard for anything to distinguish crimes that are death eligible from those that are just your garden variety homicides. And so there's been a number of studies on this looking at comparing those who are actually executed and sentenced to death with those who are not, and those crimes that are death eligible versus those that actually get sentenced. And many of those studies have found that this process is where bias and caprice come in, because there's not something distinguishing those that are being executed from those that are not in death eligible crimes.
All right. Morning, everyone. My name is Marty Davidson. I'm going to talk about some of the evidence related to geographic disparities. As Frank alluded to before, the geographic concentration of the death penalty is really centered around a few states. And so this graph right here shows before Furman and after Gregg. And what you'll notice is that after the death penalty was reinstituted, the top 5 states where executions occurred are mainly concentrated in the South. This was not necessarily the case prior to the unconstitutional ruling of the death penalty. And in addition to the concentrated amount of states in the South for the death penalty, what we see is that there are actually a huge concentration of counties, specifically in southern states, where most of the executions have been carried out. As you'll see in this graph right here, about 9 out of the top 20 counties for executions have all occurred in Texas. And so this map right here, it shows from 1984 to 2012, all of the homicides that have occurred throughout the United States. And so what you'll notice is a pattern of primarily the major cities in the United States where homicides occur. But as the next map shows, the concentration or hotspots of executions occur primarily in states where homicides is not a factor. Switching quickly to the use of execution methods, this graph shows over time the evolution of different methods to execute the condemned. And so what you'll notice is at the beginning of the 20th century, hangings were the common use of execution. Quickly throughout the early part of the 20th century, electrocution ended up overtaking hangings. In addition, you see a small spike in the use of the gas chambers. Nevada was the first state where gas chambers were used to execute inmates. And as you all notice, there was a lull before the Supreme Court declared the old death penalty system unconstitutional. But soon as the ruling in Gregg was passed down, there was a rapid increase. And what you'll notice is that lethal injection was the quick standard that states used to execute people. Now, it's interesting when it comes to lethal injection, there's this idea that because it's a medicalized process, it is somehow more humane. But this graph right here, this pie chart, it's a replication from an article produced by Canaris et al. In 2005. They wrote an article in the Lancet Medical Journal, and they did an autopsy and looked at the sodium thiopental, or the common anesthetic used to execute or used in combination when executing inmates through lethal injection. They looked at the levels within the observed autopsies, and they noticed that close to half of the inmates that they sampled were at levels below surgical recommendations. So essentially, these people were wide awake before the barbiturates were used to actually execute them and stop their heart. Switching quickly again, this graph brings in the idea of the relationship between public opinion and execution throughout the United States. And so what you'll notice is that public opinion is strongly correlated with the use of executions, the use of sentences, the number of states executing, number of counties executing, and that there's a rapid decrease over time. Now, it's important to know that correlation does not imply causation, but it's interesting that this trend is highly correlated.
Yeah, so one other topic that's come up a lot in discussions of the constitutionality and the death penalty's application is mental illness. And in 2002, the court ruled that it wasn't okay, it wasn't constitutional to execute those with intellectual deficiencies, but they haven't yet ruled on executing those with severe mental illnesses. And what our analysis showed is that those who are mentally ill are being targeted and are represented on a much higher rate in prisons and on death row than they are in the general population. So these figures here show that severe mental illness is far more common. That figure on the left shows the ratio of those mental illnesses on death row versus in the public. And you see it's 10 times higher for those on death row to have some severe mental illness than the general population. And one place that this mental illness can manifest is with those who volunteer to be executed. They give up their appeals and tell the state that they're okay, they're willing to be executed. And you see that suicidal tendencies, that having actually attempted suicide and having diagnosed mental illnesses, the rates are far higher for these individuals, indicating that, again, there's some disproportionality between who's on death row and the general population. And you see that same trend when we go back even to childhood, where those who are executed have rates of 3-4 times higher of being abused in childhood, with physical abuse. 26% of those who are executed experience that in their childhood, and that's only 2% for the general population. And one place where this can manifest in courts is the statutory aggravators. So Texas is an example. They have 40% of the nation's total number of executions, and one aggravating factor that jurors can assess when determining whether or not someone deserves to be sentenced to death is whether or not they think someone is a future danger. And a concern here is a lot of times, because of the way mental illness can be represented in courts, we see the fact that people who are sentenced to death or being considered to be sentenced to death have higher rates of mental illness than the general population. It can often be misrepresented by jurors to say this is an indicator that this person is a future danger, and it allows them, because this statute that the defendant is a future danger is an aggravator, it allows them to sentence someone to death. And you see that with the fact that there are 5 states that allow future dangerousness to be a consideration in sentencing. And of those 5, 3 are the highest executing states: Texas, Oklahoma, and Virginia. And this also comes back to questions about veterans and those who've served, because about 10% of those who've executed have been veterans, and many appear to have symptoms of PTSD. And it becomes a question of whether or not it's appropriate for the courts and for jurors to consider these as aggravating factors and mitigating factors, and to determine the kind of guidelines they need to give jurors when considering this information. And I think when you look at all the evidence that's presented right now, the court system and our criminal justice system with regards to the death penalty is disproportionately targeting those who have diagnosed mental illnesses or symptoms of mental illness. And there's a question this is a question the court will have to answer, like they had to answer with those with mental deficiencies in 2002.
So to summarize briefly the results of our book, one way to think about it is if we could say statistically who's more likely to get death, or which crimes are more likely to lead to a death sentence. There are a number of factors that are completely arbitrary. First of all, if the crime occurred in Harris County, Texas, chances are much higher than if it occurred anywhere else in America, including Los Angeles, Philadelphia, New York, any other jurisdiction, even if we limit ourselves only to those with the death penalty. It's geographically capricious. Secondly, the rates of death sentencing and execution have varied dramatically over time. So if the crime occurred in the 1980s, as opposed to the 2010s, that crime would be much more likely, probably 3 or 4 times more likely to be followed by a death sentence. Crimes with white victims are much more likely to lead to a death sentence. Crimes with vulnerable defendants, such as the poor, the young, the mentally ill, those that have difficult times cooperating with their attorneys. Now, there are some factors that are legally relevant, such as if there is torture, multiple victims, but there's so many factors that are legally irrelevant and potentially unconstitutionally arbitrary. So every study that's looked at those, and we review them in the book, have found that there are legally relevant factors that do matter, as they should, but there are also legally irrelevant factors such as race, gender, geography. Then it's worth thinking about, with almost 1 million homicides in our country in the modern period, who does not get death. It's almost never happened that a white killer of a black victim has gotten the death penalty. It has happened, I think, about 20 times out of 1,500 executions. Only 20 of those executions involved a white killer with a black victim. So it is racially extremely untargeted at white killers or people with black victims in general. Crimes in the vast majority of the counties of America will never see a death sentence because those counties simply don't execute. Worst criminals, or those committing the most heinous crimes, are not statistically more likely, not particularly more likely to get death than those who commit what some people might call a garden variety crime, although that's a phrase that we don't support because it's hard to understand. If it were your loved one who was killed, that would be garden variety. All crimes are terrible, all murders. And even among people who've been sentenced to death, odds are they won't be executed. Finally, and this is perhaps the most striking, even among those where the governor has signed a death warrant, chances are that death warrant will later be canceled or at least delayed. So with all this, we've written a book that is full of facts and figures. We don't propose the book as a how-to manual for advocacy, but it is a place to go to know the facts. And the facts really matter. It's how we can make arguments about whether or not to continue to have a death penalty system in our country. Knowing how the system has worked, in fact, on the ground is important to evaluate it. We think that it's important for us to change the conversation away from an abstract one based on morality to a more specific one based on how the system is actually working. And I think that the arguments about mental illness, that we've actually been targeting the mentally ill, would be shocking to most Americans. Most Americans are quite surprised with the cost argument. Many people continue to believe that there might be some deterrent value to the death penalty, but this has been definitively rebutted by the National Academy of Sciences, partly because the alternative to the death penalty is not that you go free and don't pay any cost for your crime. The alternative to the death penalty in most states is life without the possibility of parole. So that's another form of a death sentence. So it's hard to know what would be even the logical deterrent value of capital punishment, considering the next most difficult punishment is life without parole. Finally, many states now, 6 states have recently abolished the death penalty and have done so through the political process. And the political leaders that led those abolitions have not suffered at the polls. So public opinion is moving strongly, and evolving standards are moving strongly in the direction of abolition. So we look forward to your questions, and I hope this has been a useful conversation for you.
Frank, are the questions being emailed to you?
I don't see any questions, so I'm just going to wait.
If you go to the chat section, people are submitting questions. Yeah.
Okay, I'm sorry I didn't see the questions, but the first question I see is from Puerto Rico. And the question is whether the book considers specific and particular situation in Puerto Rico. I would say that Puerto Rico is a very peculiar situation because the island itself, like the District of Columbia, the state of Michigan, and other jurisdictions in the United States or state of Massachusetts, does not have the death penalty. But the federal government has occasionally sought the death penalty. So the question is, do we really consider that in detail? And the answer is we don't go into a great deal of detail about that particular question in Puerto Rico, but we do note the peculiarities of the federal government coming into jurisdictions that do not have the death penalty and applying it there. The particular case about Puerto Rico is even more interesting because they'll do so in the English language only, and so it's particularly troublesome, but that's a very good question. There's a question from David Dodge about the diminishing availability of drugs for lethal injections. Perhaps, Arvind, do you want to talk about that?
Yeah, sure. So this has been something that the court has even handled recently in Glossop v. Gross, and that was one of the cases that even motivated the writing of this book. But a lot of states have had difficulty securing drugs for lethal injections, and that's a big reason that it's been less common for executions to have taken place recently. But what the court has said is that, in maybe a reasoning that sometimes isn't always clear, is because the death penalty is constitutional, there must be a constitutional way for people to be executed. So I think that this is a question that's going to continue to come up to the courts in the future. So
there's a question from Aaron Barnhart about the percentages of defendants and victims involved in wrongful convictions. Wrongful convictions involve, in death cases, so far identified 160 people have been exonerated. There's been about 14 to 1,500 executions. So one way to think about that is that there's an exoneration for every 9 executions. So it's almost 1 in 10. There has been a very good detailed study about the likelihood of erroneous conviction, and that estimate came out to about 4% of people sentenced to death were sentenced erroneously. That would imply that almost 350 people on death row may have been innocent. So we know that 160 of them have been exonerated, so there's probably at least that many still on death row today who have not yet been exonerated. So I want to thank people for their questions, and mention that we're going to have 2 additional webinars in this series. In March, David Harris, the Executive Director of the Charles Hamilton Institute for Race and Justice, will discuss understanding the root of the problem and building safer communities. And in April, Susan Herman, author of Parallel Justice, will discuss focusing on healing and how the death penalty system fails its victims, the victims of the crimes. So thank you so much for being with us today.
Thank you.